Hi, welcome to Foster Friday Live. We are so glad that you are joining us today, and I am so excited to be talking about the foster care court process. I know that it's maybe not every foster parent's favorite thing to talk about, but I'm so grateful to have you here today because maybe we can understand it a little bit better, and as we understand our role as foster parents in court, hopefully it feels a little less intimidating. So do you mind just introducing yourself to everybody?
Sure. I'm Robert Cohn. I'm my job title now is Assistant Managing Attorney for County Operations for the Department of Social Services Office of General Counsel. What that means is I, along with my boss, supervise the county legal departments for the 46 counties in South Carolina. I've had that position for about a year, but for most of my career, I was a county attorney in the Greenwood, Abbeville, Newberry, and Lawrence area.
Awesome. So just a small job. Yeah.
Just a small job. And I've been practicing law for about 23 years now. And for most of that time worked in the child welfare system, as I was telling you before.
Yeah.
I actually spent the first 10 years of my career representing parents in abuse and neglect cases, and then switched sides and started working for DSS back in the early 2000s, and have been doing it ever since.
Yeah, well, thank you so much. And as you guys join us, just let us know that you're here, and as you have questions, because I'm sure that you do, we've already taken some of your questions, just let us know, and we're going to try to answer those. So can you tell us a little bit, as a DSS attorney, and now as someone who manages DSS attorneys, can you talk to us a little bit about what that role is and kind of what they're responsible for?
Sure. DSS attorney, they have two main roles. The biggest one, obviously, is being the advocate for DSS in court, representing the interest of the agency, which is obviously we're there to look out for the children, to represent what the children need, make sure if they're out of the home, that they need to be out of the home, and they need to stay out of the home. We advocate for what sort of treatment services need to be put in place for the parents, or if no treatment services should be offered, and we need to either find relatives to put the children with, or terminate their parental rights and place the children for adoption. But our role as an advocate is as we prepare all the paperwork to get cases into court, to explain why DSS is involved and why the children are in foster care, and what the department thinks needs to happen based on that. And then we make court appearances. We draft all of the orders that come from the court, are actually drafted by the DSS attorneys and then submitted to the court for signature. And then we take care to make sure all of those that everybody who's involved in the system is served with those legal papers, notified of all the hearings, and also just keep up with, are we having the hearings in the time frames that are required by law, and that we're keeping track and we're moving cases through the system the way they're supposed to, at least. So that's our role as an advocate, is to handle all the court aspects. Our other role is a counselor for the agency. Everybody talks about attorneys and counselors at law. Well, the counseling part is where we give legal advice to our client, which is the department, DSS. Okay.
So like the caseworkers.
The caseworkers and their supervisors, and they come to us and say, okay, here's the situation we have. What are our options legally? Can we, do we have enough evidence to bring a case to court? What, if not, what do we lack? What do you think, will the court approve? This is the plan we want to adopt. Will the court approve it? What evidence do you need to back that up? And so we're pretty heavily involved once a case is at the stage where it needs to go to court or is in court. We start getting a little more involved in case management, I guess you'd say, because at that point we're having to say, okay, well, how am I going to present this to the judge and explain what needs to happen? Some of it is when the court has ordered us to do certain things, like, okay, we have to get a paternity test done. Part of our job is we follow up to say, well, did you do it? And do you have the results? How about, did you send mom and dad for a drug screen? Do you have the drug screen report? So because it's our job to make sure the court has all of that information. So we're behind the scenes.
So it sounds like you're kind of coming before, you're in the middle, and kind of following up kind of with afterwards. Right.
We do before, during, and after. We have parts to play in the system.
Right. So now, and you were kind of saying that there's typically just especially with the smaller counties, just one attorney for
That's right.
DSS in each county, and they're managing each of those cases pretty much on their own.
Right. And actually, it's not one attorney per county. In the smaller counties, you usually have an attorney who's covering multiple counties.
Wow. Okay.
For example, our attorney, for a lot of the attorney who took my place covering Greenwood, Abbeville, and Newberry, she covers
That's
3 counties worth.
3 counties.
And so she has to travel and meet with the staff in all 3 of those counties, do court in all those counties. So that's one thing that a lot of folks don't realize is that attorney it may only be that the county you're in may only have court once or twice a month, but they're doing it in other counties too. And when new children come into foster care, they're having to do 72-hour hearings, or what we call probable cause hearings, and those we never know when those are coming. So you get a call, hey, we got a new kid. Quickly draft all the paperwork, get it filed, and schedule a hearing, and then you have to go. And sometimes that's in, if Abbeville has a kid come into foster care today,
right.
And on Monday, or Tuesday, since Monday's a holiday, but on Tuesday we're going to be having a hearing in Abbeville, or if they don't have a judge in Greenwood, we're going to have a hearing.
Wow. So is there maybe an average or a typical number of cases that any one attorney is managing at a time?
I can tell you this, the American Bar Association nationwide recommends that child welfare attorneys have a maximum caseload of about 75 cases that they manage. Wow. On average, attorneys in South Carolina are managing in general 100 plus.
Wow.
And it does vary. I mean, you can there are parts of the state or the smaller counties where they don't have that many, but then you can have some counties where they have a very large caseload. I have attorneys that are managing 200 cases right now, and I'm trying to keep up. And when they do that, that's when we start seeing, can we pull in extra help? We do have some attorneys that we call contract lawyers who don't work for the department, but they're private attorneys, but they're contracted to come help us. And so sometimes if we can pull one of them in to help, or we get attorneys from an adjoining county to pull them in if it gets too bad. I know we've had several counties where we just had to do that.
So I think probably one of the most confusing things for foster parents, especially when we're new, is just kind of how it even works. What are the different hearings? When do they happen? What happens? And what is our role in them? So can you just kind of walk us through, obviously there's no typical case, but like a typical case, what does that look like? What's the first hearing, or what's the first thing that happens?
Absolutely. Well, the normal process for a child comes into foster care, whether by law enforcement or court order, there's going to be a hearing within 72 hours. Now and there's some exceptions if there's a holiday or a weekend in between. Right. It might be 4 days or 5 days or something, but generally we have to file what we call a summons and complaint, which is the legal pleadings that start a court action within 24 hours. And then we have to have a probable cause hearing within 72 hours. And in that hearing, it's mostly just going to be, the child will be in a foster home. Presumably, we always try to let it be the home that they're going to stay in for the duration. Sometimes it's an emergency placement until they can find a longer term option. But they're in that foster home. Most of the foster parents may or may not know about the date of the probable cause hearing. The caseworker has to tell them about that because we haven't gotten the paper. We're just getting the paperwork done. Okay.
I've literally never heard of
and
the
you
probable
may not.
cause hearing.
Well, and the probable cause hearing is extremely limited. It's a 15-minute hearing.
Right. Well, if it happens in 72 hours, there's a lot of other stuff happening in that time.
All that's decided there is, was there what we call probable cause, which is, from a legal standpoint, is just there's a good reason for that child to be in foster care. You're not proving anything at that point. There's no findings that the child's been abused or neglected. It's just there was a reasonable suspicion that something bad happened. And most of the time they consist of, if a police officer took the child into care, they testify. Maybe the caseworker just say, hey, sometimes we'll request, like, can we get the parents to do a drug screen, or we need to go ahead and start paternity testing if we know there's a question about who the father is. Sometimes we use that to get some information about the parents if they're there. In many cases, they haven't been served with the legal pleadings because it happens so fast. Wow. A lot of times we serve them at that hearing if they show up, because they'll hear about it from friends or relatives or whatever. But usually that's about it. There's one or two witnesses, and The parents, if they're there, can ask questions, but they're not allowed to testify. They can't present any testimony or call witnesses or anything like that. They can, if they have a written sworn statement called an affidavit, they can present that. I don't think I've ever had a parent actually do that, because they don't know to do it. And at that point, they generally don't have attorneys, but they're advised of their right that they can request an attorney and go to the clerk's office and apply. So that's the first step. And that's
so they come into foster care, probable cause says, yes, there is reason.
There's reason for the child to stay. And so now we're going to have a merits hearing. And that's got to be held within 35 days of the child coming into foster care.
And that's typically the first hearing that foster parents are hearing about.
Right.
And should be invited to attend.
Foster parents should be told when that hearing is. You don't get copies of the pleadings. You don't know what, you may not necessarily know what the exact allegations are about the parents. The caseworker may give you some idea of, they're sort of going to tell you if the child's got needs based on the nature of the abuse. They're going to tell you that, so you know if they've got medical issues they need to deal with or whatever. But you will get notice of that hearing, that they're, the date and time when it's going to be. Merits hearings pretty much across the state, we have them set up as what we call a first call merits hearing, and those are also only set for 15 minutes.
Oh, okay.
Because in a perfect world, we would go ahead and have the trial at that 35-day stage and just be done. As a practical matter, we still have parents, sometimes they haven't been served yet, or they've been served, but they haven't requested an attorney and they want an attorney. So they're advised that, particularly if they weren't at the probable cause hearing, the court has to inform them of their right to do that. And if they're going to contest it, I'm sure if any of your foster parents have been to a court day, you'll notice there might be 20 hearings scheduled that afternoon.
Which is impossible to get through 20.
You can't get through all of them in an afternoon, even if you have a whole day.
Right.
So what happens is we use those as a first merits. And there are many circumstances, in many cases, where we come in and the DSS presents to the parents, here's what we want. Here's what we want you to do. This is your treatment plan. We're going to keep your kids in foster care for now. Or if we've identified a relative at that point, we may put them with a relative. But if they're staying in foster care, this is the treatment plan. This is that we want a finding that the child was abused or neglected. And and this is the visitation schedule we're going to set up for you for right now while you work your treatment plan. If they agree to all of that, then we can put that agreement on the record, and we don't have a contested trial.
Right. Okay.
At that point, we just move forward with treatment, and we're going to come back at a later point and review how the parents are doing. But most of the time, it's hard to get in a grip, particularly when children have come into foster care. Usually, things are still moving. The agency sometimes hasn't finished its investigation because we're waiting on the results of a forensic interview, or we're waiting on the results of a drug screen or something that we didn't get. In smaller counties, sometimes the hearings those first call merits can take place really quick. I mean, they can be like 10 days after the child comes into foster care. Because if, for example, I'm familiar with Greenwood County. Greenwood County has one afternoon a month as their standing docket day. So if a child comes into care today and our docket day is,
next week or
the following Monday, we've got to get that hearing scheduled within that 35-day window.
Because otherwise it would exceed
Otherwise it's going to go past that deadline. So sometimes that first merits is so quick, it's kind of like the probable cause hearing. Nobody's really had time to get it together. Ideally, we've had enough time to at least get some idea of what's happening and come up with a plan, and that's the idea. Usually what happens after that, assuming we don't get a resolution at that first merits hearing, it will frequently be rescheduled for what we call a second call merits. By then, the idea is, okay, everybody now has an attorney that wants one. Everybody's been served. It's been about 60 days or 65 days. And we have a better idea, once everybody's got a lawyer, can we really have an agreement or do we not? If it's going to be contested, because then usually at that point, okay, well, how long is it going to take to have the trial? Is it going to be, can we do this in an hour? Is it going to take a half day? Is it going to take 3 days? And that's going to depend on what the defense attorneys tell us and what we think based on witnesses. Some cases are really complex. If it's severe physical abuse, for example, we're going to have to bring in doctors to come and testify about broken bones and what the x-rays tell us and things like that. Some are simpler and we only need 2 or 3 witnesses. But the defense attorneys can also say, no, I'm going to bring in this expert and that expert and bring in these other people to defend my client. So we have to get input from everybody in the system as to how long it takes. again, that's a hearing. Every merits hearing, you should be noticed as foster parents. You should get a notice that there's going to be another hearing.
And that's a written notice comes in the mail.
You get a letter
from the
that says
department.
from DSS saying there's a hearing on this day and this time, and you have the right to speak and be heard at that hearing. Understanding that sometimes those hearings, if we don't have an agreement, there may not be a whole lot said. It's just we're not in agreement. We don't have time. We need to set this for a 2-day trial or a day-long trial. And then at that point, depending on the county, some counties go ahead and pick that court date right then. Some they say, okay, we'll have to check with the clerk's office and see when we have time to do it and get back to everybody, afterwards.
So after a merits or two merits, an agreement is made.
If you have an agreement, then at that point you're going to go. At that point, the next step is depending on what the terms of the agreement are. Sometimes we do what we call a judicial review hearing, like 90 days out to see how are the parents doing. Are they making progress? Are they not making progress? Do they need additional time? But we don't always do that. The next hearing, in many cases, like a lot of treatment plans, are 6 months. Right. Is kind of typical. So usually by about that point, the next hearing, we're going to be looking at doing a permanency planning hearing. And the purpose of a permanency planning hearing, but in some ways, permanency planning and judicial reviews are actually very similar because both of them are intended to give the court an update on the status of the child and the status of the parents and what's the agency's plan moving forward. But permanency planning hearings are required by federal law, and there's some additional requirements that we have to explain what that we have to state a specific plan that we're pursuing, and that can be reunification. It can be granting an extension for reunification, meaning we're going to give the parents a little more time to work on their treatment plan, or we've now identified a relative, so we're going to place the child with a relative, or if they've made no progress, we may be pursuing termination of parental rights and adoption.
Right.
If the child's 16 or older, we can also talk about a plan called APLA, which just means that they are old enough that they're not likely to be adopted, or they don't want to be adopted, because at 14 and older, children get a vote as to whether or not they want to be adopted. And if they say no, they can't be adopted. We can't put them up for adoption.
Wow.
So, and there's a little disconnect between South Carolina law and federal law, because they changed it where you can't order. APLA is our transition program to adult living. Yeah. So if you get that, then we're just going to keep working with you to help you decide if you want to go to college, help you finish school, get your GED, make sure you have a driver's license and place to live, and help you find work if you're not going to pursue college. We work with, just like you would with any child who's turning 18, as over that 2 years heading up to that, we're going to give you that option. And we're going to talk to them about that there are options to actually stay in foster care after 18 and still receive assistance from the state.
Okay.
You can do that. A lot of folks don't know that. You can actually, but the child has to voluntarily stay. At 18, they can leave. But if they choose to stay, we continue to provide some assistance to them to help them make transitions. But that's most cases y'all deal with. That's not really an issue. But at that permanency planning hearing, we're going to present the plan. Usually, there's two plans. There's the primary plan and what we call the concurrent plan. And that just means the primary plan is what we're really working for, but the backup is this.
Right.
Most commonly, it's reunification with an extension concurrent with termination of parental rights. And one thing that's changed over the last year or so, we've now made it a policy that whether the primary or concurrent plan is termination of parental rights, the attorneys are supposed to be filing a termination of parental rights action within 60 days of that hearing and scheduling the termination of parental rights hearing. Because we ran into a problem where we were giving parents a lot of all this extra time and then waiting till that extra time was up before filing for termination of parental rights, and that just drags the process out further. So we've moved to where we're going to set it. It still takes, of course, it takes months to get a hearing on it for termination of parental rights. So the parents can still be working their treatment plan even though we filed the action. And if we get to that hearing and the parents have done everything and we're satisfied the child can go home, they can still go home. But that creates some confusion because, but you also, you're saying reunification, but you filed for TPR. Right, where it's because we're required to. It's basically us taking into account the fact of how slow the court system works. If we could schedule hearings within 60 days like you're supposed to be able to, we might not do that. But because it can take 3, 5, 6 months or longer to get a hearing scheduled, we're going to go ahead and start that process, recognizing that hopefully by the end the parents have done what they're supposed to do. But if they haven't, then we're set for the next time we're going to do TPR.
And you continue to have those permanency planning hearings every 9 months until either the child goes home or they're no longer in foster care for some reason.
Every 9 months while the child's in foster care, or so up until until they reach 18.
So then from there, let's say that the reunification wasn't possible. The next hearing would be TPR and then adoption.
Right. And TPR is actually a separate legal action that has to be filed. It's different. When they first come into foster care, we call that a removal action. That's the hearing where we removed them. But when we get to where we're going to terminate parental rights, we actually have to file a new legal action. It's separate because the grounds for termination of parental rights are different and the standards are different. Some people call TPR the death penalty of family court because the standards we have to meet are so high to prove that it's okay to terminate these parents' parental rights, and we have to meet certain statutory requirements that we can prove these things. And so it is a separate legal action now. But again, if you're a foster parent, you get notified of all of those hearings too, and you're allowed to participate in all of those hearings or observe them as you desire. So sometimes by the TPR stage, it's not uncommon for foster parents. We sometimes ask if you'd like to testify as a witness, because at that point, one of the factors is if you're the foster parent that's going to adopt the child, how are they doing in your home, or your family, you really want to adopt them, this is your desire. So usually won't be about the facts of why TPR is appropriate, but one of the things is the court has to say, is it in the child's best interest? And a lot of times foster parents are good witnesses for that issue to show that they're in a good home and are going to stay in a good home. So we will sometimes ask foster parents to testify in those proceedings.
So that's kind of the way that the hearings work. Just really quickly, as we think about that process, what is the foster parent's role, or maybe even what are their rights in that legal process? Well,
foster parents have the right to information about the child that's relevant to you being able to care for the child. So if they have particularly if the circumstances of how they came into foster care are affecting their health, mental health, if we know they have developmental problems or educational issues, things like that, you're entitled to that kind of information. And as we as an agency learn it, we're supposed to be passing that on so you can, because of course foster parents are the ones taking them to the doctor's appointments and the counselors and so forth. You have the right to be present at all hearings and observe all the hearings. You're supposed to be notified of all the hearings. So if you hear comments that, there's a hearing coming up and you haven't gotten something in the mail from the legal department saying, there's a hearing on such and such date, you need to follow up on that, because as part of when we notice everybody else, we're supposed to be sending you a notice. It's going to be it's a different notice. It doesn't look like the documents everyone else gets, but it just tells you the date and time of the hearing. And then when you're at the hearings, you have the right to be heard if you want to be heard. You're not a party. You can't call witnesses or cross-examine witnesses on the witness stand, but you can make a statement to the court about what's going on with the children, what are your intentions, how do you think they're doing. Just I've had foster parents, if foster parents are really involved in visitation, like maybe they're present and are participating in visits with the parents, you can talk about how those are going, or what the kids say about their parents or things like that. But you're allowed to speak. You don't have to. It's a right you have. If you want to be heard. Some foster parents don't. A lot of times they don't want the parents to know who they are, and you do have to be identified if you're going to speak in court. There has to be a record of who talks in court. So you do have to at least give your name. Some foster parents don't want the biological parents to know anything about them, and that's understandable. So you don't have to. Some foster parents just want to sit and watch and see what happens, but you're allowed to just do that. And one thing I do advise foster parents, if you want to speak during the hearing, if you've been to family court on DSS day, it's kind of a circus. There's people all over the place, and that attorney, or even if there's a couple of attorneys, there's just lots of running around. It's very important to let the caseworker know that you want to speak and make sure they've communicated that. If you are able to tell, if you can find the attorney long enough to tell them that, to introduce yourself and tell them that, or if you can ask who the paralegal is who's assisting the attorney, sometimes you can tell them. You just let them know you want to speak. Because I can tell you, as DSS attorney, we're the ringmaster of the circus,
through.
and we're
Yeah.
trying to keep up with lots of stuff. And if somebody doesn't tell us that the foster parent wants to speak, we sometimes don't know you're in the courtroom if
Right.
nobody tells us that. So it's okay if at the beginning of a court, the attorney, the DSS attorney is always saying who all's in the courtroom, defendant so-and-so, and here's their attorney, and the guardian ad litem is this person. If you're there and we don't call your name and you want the court to know you're there, tug on somebody's sleeve and say something. Yeah, that's okay. You're not going to bother anyone. That's part of it, and it's not any slur that that we're deliberately trying to overlook you. It's just if we don't know, a lot of times we're trying to figure out there are lots of people in the courtroom. There are grandparents or aunts and uncles and custodians, and we don't know who they are either. So we have to try to keep up. But you have the right to be there and to speak. There is a difference. I have foster parents who say, well, I want to really participate. I want to be able to call witnesses. I have evidence, I think, and I don't think you, DSS, or the guardian are telling the court the whole story. Mm-hmm. To do that, you have to file what's called a motion to intervene and ask to become a party to the case.
Okay.
And they have to have a separate hearing on that. And if the court rules that you can intervene, it's up to the court whether or not to allow it. But if they do, at that point, you are a party to the case, and you can call witnesses, and you can present evidence, and you can cross-examine the other witnesses that testify in the court proceedings. If that's something you want to do, my recommendation to any foster parent that wants to do that, talk to a lawyer before you do it. And the DSS attorney can't tell you whether that's a good idea or not, because that's legal advice. Mm-hmm. Same with the guardian attorney. They represent the guardian, so they can't tell you that. But I have foster parents that do that want to be part of the process.
Typically would be something that a foster parent does if they disagree with a plan, or they just want to be more involved, or
the times
they feel they have other information to share.
Most of the time, when it's not very common, I should say, it doesn't happen very often. When it has happened,
that sounds like a lot to me to take on.
Usually, there's some extraordinary. So it happens to be. It always tends to be in my most complicated cases that have kind of gone. To my mind, has sort of gone off the rails. Maybe they've gone on too long, or the agency's changed its plan too many times, or the agency and the guardian are disagreeing about what should happen. And the foster parents, for whatever reason, are just not comfortable with how things are going. But it's rare.
Yeah.
And
I would assume that the foster parent has to take on all financial responsibility for that attorney.
It comes out of your pocket, which is the other issue. There are some free legal services out there if you qualify for that, but I very rarely see them get involved. So most of the time, if you have concerns, if you communicate them to the caseworker or to the guardian ad litem, that's part of their job, is to communicate those to the court. And as long as you're maintaining an open dialogue with them, they know what is happening. You know? And so that's how that should come out. But we do have, there are foster parents that do want to get involved to that degree, and I have seen it from time to time for different reasons. It happens sometimes foster parents say they want to adopt, but that's not the agency's plan. And so that suddenly, because the agency has some statutory obligations to try to return. Right. We're legally obligated to try to return children to their parents. And in the alternative, to give children to a relative as opposed to a parent. Well, as cases go on and children have been in foster care a long time, foster parents are like, I want to keep them. Mm-hmm. And if that's not the agency's plan, we can't necessarily advocate for that. We can let the court know that you want that, and you can let the court know during the hearing. But some foster parents want to take a more aggressive stand on that and actually bring their own action to try to terminate parental rights and adopt the children, as opposed to working through the DSS system to do that.
Right.
So it does happen, but you should, as any foster parent, you should know when all the hearings are taking place, be able to go to the hearing and attend, and speak if you want to speak.
So what would your recommendations, just kind of basic recommendations for a foster parent who wants to advocate for their child wants to support the child's plan or the child's family? What would your recommendations be for those foster parents in terms of the court proceedings?
In terms of court proceedings, the most important thing is to, again, maintain that open communication with the caseworker and the guardian to say, and to tell them what you think is going well, what you think is not going well, or concerns you have. some of that also depends on how involved you as a foster parent are. Of course, a lot of times you're the one going to the counseling appointments and you're going to the doctor's appointments, and the caseworker may not always be at those. So certainly making sure that they're aware of what's what's said at those, or what's being recommended. Like if they're saying, if the children, every time they have a visit with mom or dad, they're getting upset and they're throwing tantrums at home, or their grades suddenly go bad at school, or they have discipline problems at school. Caseworkers need to know that, and they don't always get that information. You as a foster parent are more likely to hear about issues at school or from a doctor a lot earlier. So the caseworker needs to know that, and as does the guardian. And whether that's by sending them emails and just giving them kind of an update periodically about what's happening, that's the best thing. And I have foster parents who are really involved in it, like they're participating in the visits with the parents, but that's a choice. I always tell foster parents that's if you're comfortable doing that, and because at that point the family's going to know that those biological parents are going to know a lot about you, and if you're not comfortable with that, you did not balancing that. I have some that really engage with them and talk to them on social media and things like that. And if you're comfortable with that, that's fine, but you don't have to.
So Laura says, how does a foster parent speak at a hearing? I've been in the arena for a long time, and I've never seen a judge ask for the input of a foster parent. I've even seen when the foster parent tells the guardian and the caseworker that they would like to speak, but nothing happens. What is the process to make sure the foster parent gets heard?
If you go around and you've particularly if you've told the caseworker and the guardian and that you'd like to speak and nobody brings that up, just stand up when there's a lull, maybe at the end or when the DSS attorney's done with their part before they move on to the defendants or move on to the guardian.
Right.
You need to just stand up and say, Your Honor, I'm the foster parent. I'd like to be heard.
So it sounds like, Laura, and I mean, because if you don't know that you have a right to speak, that seems really intimidating to just stand up in court. But I guess if you do have the right to speak and you have let them know already, and you still aren't, you can.
Well, and if you're standing up and the judge may say, well, I'm going to let y'all speak, but I want to let these other sides speak. They'll tell you that.
Right.
And judges are always very intimidated. Court is intimidating.
Yeah.
Judge, black robe, and deputies and all that. But they're people, and they understand. I mean, they're not going to hold it against you that you are asking to be heard. They may say, okay, ma'am, I'll get with you and I'll come back to you in just a minute. And that's, but just let them know. And if they I would hope if you told the caseworker, speaking as DSS, if you told people that you want to be heard, that they would have passed that on. If they're not, that's something either before or after the hearing, preferably at least after the hearing, kind of let the DSS attorney know, hey, I wanted to be heard and nobody asked me, because we do get caseworkers who don't understand. We have caseworkers who are scared to talk to the attorneys and are scared to talk to the judge because they're kind of new and it may not occur to them because they're dealing with stuff. Maybe they've got 4 cases that afternoon and they've been working on something else and they forget. They're human. So, but never be reluctant to stand on your rights. If you want to be heard, you have the right to be heard. And I've never seen a judge, throw somebody in jail or that you cannot speak. If you ask, they're going to let you speak. They may eventually if you go on for an hour, they may kind of say, okay, I think I've got it. But they do that to the lawyers and and the guardian too. If we start rambling, they'll do that. So that would be my suggestion.
Thank you, Laura. That's a great question. So a lot of the questions that we got kind of before this from foster parents were about, what do you do if something goes wrong? This is how it's supposed to work, but in this case, it didn't work this way. I wasn't notified, or I disagreed with the decision made, or I wasn't notified and then something happened, or I was told that the plan was, we were going to go into court and the plan was going to be this, and then somebody stood up and said something totally different. So what maybe advice do you have for foster parents, or what can foster parents do if they feel like they disagree with something that happened, or something didn't happen the way it was supposed to?
Well, okay. And I'm always going to go back to communication, because while you should get the notice in writing from the legal department, your caseworker should also be telling you when you have court. Right. So one thing to watch is if your caseworker says you have a hearing coming up, but you never get a written notice, that's a red flag. You need to contact, if not the caseworker, the county director or the county attorney to say, hey, I didn't get notice of this hearing.
And the information for the county attorneys is all online. We can find that information on DSS. I think if you just search the county attorney.
If you go to the DSS website, one of the tabs is about. Okay. If you pull that down, there's one that says legal team. And if you click on that, it gives you a directory of all the attorneys for every county in the state. And we'll make sure we link that here too. But so that's but that's an option for foster parents, is to reach out directly to the attorney. You can. There's nothing that says you can't talk to them. Again, they're gonna probably send you back something on the lines of, I can't give you legal advice. But if you're particularly if it's something like, I'm not getting notice, they will say, okay, we'll make sure that that's going, because that's an oversight. Right. Every once in a while, particularly if there's been a recent change in foster placement, we sometimes don't know that the child's been moved, and so we sent the notice to the old foster parent, not the new one. But you should be. Then if you know there's any kind of hearing and you did not get notice, that's a flag to either talk to somebody at the county staff or just contact the county attorney directly and say, I do want to be notified about that. Just because that should not be happening. As far as things not going the way you expect at court, I wish I could say that doesn't happen, but it actually happens all the time, because we'll walk into court with one plan, and then as you'll see in court, there's all kinds of negotiation going on, and unfortunately, under the law, foster parents have a very limited right to be involved in those negotiations, because they're getting into the substance of what happened and the parents and so forth. Because we have right to information about the child, but not necessarily right to information about the what's
parents.
What's going on with mom and dad and what's their situation. So there you kind of have the best advice I can give about that is to make sure your caseworker knows, say, look, I understand this is the plan. If that changes, will you come tell me, so I'm not surprised in the hearing? And you're allowed to offer some input. Yeah, it's the same thing. It sounds like advice might be to just go to court. Go to court if you can. Well, the best thing, because I do have foster parents who will contact our offices and complain, well, the plan was this. And I said, well, did you go to court and hear it? And they're like, no, they didn't go. They knew about it, but they chose not to attend. I'm like, well, I mean, that's the best thing, is to be there, because things do change. Which I can say, if you're working full time and you've got a bunch of kids to manage, it can be hard when you show up and you're waiting all day, or maybe you get continued once, twice, 6, 7 times, but still the best thing to do is go to court. Right. And again, keeping in touch with your, because plans do change. And a lot of times we'll find out something right before court that we didn't know going in that changes our plan. The plan might have been returned home, and then mom got arrested over the weekend for something. Well, the plan just changed. Yeah. We're not going to do that. A relative that we didn't know about has suddenly come forward. And so now the plan at least has to change enough to say, well, now we've got to check out this relative for placement, and they live in Oklahoma. So we're going to have to go through our interstate process, which can take a while. Yeah. Those things, they do happen. We have, because sometimes some of those defendants don't communicate with us, but once they meet with their attorney, they'll say, I finished my treatment plan, but they won't show us anything or they've done it. Then they'll give it to their attorney, who gives it to us the day of court. Okay, they did do it. But we didn't know that, and so, well, what do we do? Now they finished it. The plan was, it was okay. Plans do change, and I wish I could see it. We try not to have it change radically, as far as from TPR to reunification on the same day. Right. But it does happen, because it's a fluid. It's a fluid situation, and particularly if the cases are getting continued all the time. It's also fair to contact your caseworker or even the attorney's office to say, hey, this is I got to work, and this is my forte. Are we really going to go? Right. Because but they might not really know, right? They don't. And can they give you some sort of idea? They can. They can at times, and because I will say this. The only time we can say for sure is if we schedule what we call a day certain hearing. Those are those contested hearings where particularly we know it's going to take more than an hour or two, and we need a half day or a whole day or multiple days. We know when that's going to be, because the court's going to give us a specific set of days and time. That's just for you. And we only get those when we're 99.9% sure that that case has to be tried and the judge is going to have to make a decision. At that point, we've already made multiple attempts to reach an agreement and have not done it. Doesn't mean parents won't occasionally show up at that hearing and suddenly agree to what we offered them a year earlier, but those we know for sure. If it's a standard, one of our standard docket days, and they tell you there's 25 cases on the docket, just recognize that we may get to it, but we can't say for sure if it's going to be reached or not. But it is a good idea to reach out and say, well, what's the likelihood? Because we do have a priority that we try to follow that may or may not make sense to y'all. Like but just to give you things when I'm calling a docket on the day, I try to look at, are there cases where if I put it in front of the judge, a child can go home? I don't let kids not go home because we ran out of time. If we have defendants who are in the Department of Corrections and a correctional officer has had to drive across the state to bring them there, we try to get them in early so that they can get back on the road and they're not, and sitting there all day. Not because we care about the prisoner more than we care about foster parents, but because the corrections officer has to, it's two of them, have to go drive them across the state and take care of them, buy them dinner, all that kind of stuff. So we try to take that into account. We have defendants who are a security risk, and the deputies in court will ask us to get them in sooner because they are violent and they're afraid of what they're going to do in court. We have and of course, like permanency planning hearings are supposed to take priority over other kinds of cases. If we have a quick, there aren't many of these, but if we have a quick termination of parental rights case that can be done, those are cases where basically the parents just never showed up, never contested, and they've been served but have not participated at all, and so we can put it up fairly quickly. We might try to get those done, but there are the reality is 25 cases in 3 hours, that's less than 10 minutes a case. It can take us more than 10 minutes to get everybody in the courtroom and seated. Right. So we do tend to run out of time. If you've been there an hour or so and you feel like, are we going anywhere? It's also through the afternoon to kind of check in when the attorneys come out, or as the caseworkers, or you talk to your caseworker when you see them and say, hey, or am I wasting my time? Are we going to get this done today? But I've gone to court and had 25 cases and I had 14 of them settle or go home. I almost always go to court and we'll find out that like 5 of the cases have to be continued. Right. But I'll know that morning or that day because I'll find out the defense lawyer's sick and we're going to have to continue the cases, but I didn't find that out till that morning. Or
now, what if parents don't show up, like the biological parents? What if they don't show up? Is that an automatic continuation, or is that
not necessarily? That will depend a little bit on the judge. If they have attorneys and their client's not there, the attorney's usually going to ask that it be continued. The judge may or may not allow that. So, why isn't your client here? Right. Because they're represented. If they're not there at all, and we can prove that they were given proper notice of the hearing, we're always going to ask to go forward. And so, well, they're not here, judge, and they knew about it. But I do have judges who say, well, I'm not real comfortable. I feel like, we should probably give them a chance. I'm not crazy about those judges because I think that's excessive. We can knock this one out in just a few minutes, Jay, since they're not here. As long as we can prove that they got proper notice of the hearing, we're supposed to go forward. But we do have attorneys who will, particularly if they have defense counsel, that puts them in an awkward position to try to defend the case when their client didn't show up. And so they will always make an attempt to continue the case. And if they can, they're usually out in the hallway trying to call their client to say, hey, get up here. But a lot of times defense attorneys, their client changed numbers and didn't tell them that. So defense attorneys have trouble. Right. I get a lot of defense lawyers would call me and say, hey, do you have a number for my client now? Because the one they gave me doesn't work anymore. But it should not, the parents not being there shouldn't be a reason. The guardian not being present because they're sick or something usually will trigger that because they're supposed to. So
if someone's missing, like a lawyer, a guardian, a caseworker, a judge, or
caseworker, it should not be continued because the caseworker is not present. Our policy is if the caseworker is out, then their supervisor can step in and testify for them. Okay. Every once in a while, it'll be like if it's a merits hearing and a big part of our case is dependent on what that particular caseworker saw or heard. and they're a critical witness that we have to have, we might have to continue it, but we try not to do a lot of that, because most of the time what the caseworker is testifying to, their supervisor could also testify to in terms of the plan.
All right, so Director Leach says thank you for your work. So thank you. And then Christy says they've always had the opportunity to speak. Laura says thank you. Crystal says it's so tricky, but thanks for spelling it all out, especially for those of us who are seasoned. It's nice to have a refresher, and I know that that's true for me too. Like, we've been doing this for a little while, but it's still confusing, and nothing seems to happen the same way twice.
And I will say this. To some degree, how court goes does vary a little bit based on the judge, because ultimately the judge decides what order cases are heard. Judges have their own standards about the kinds of cases they want to hear first. And they will sometimes say, no, I want to do this one. They're heavily influenced by the courthouse deputies. So they're a lot of times the ones say, no, I got this crazy person back in the back and I want that heard first so they can get them out of here. So sometimes, even though that's not the one we want to go first, the judge gets to as the final decision maker on that. So they have their own preferences. Most of the time they defer to us, but there are some that want to be more active in how cases get heard. So
yeah, and we're going over time, but we're getting way more than you signed up for. But just really quickly, as you're talking about things changing a little bit by the judge, how much of this varies by county or by region? A lot. Yeah. Okay.
A lot. Some of it just because of the size of the county. It's very different going to court in Greenville than it is in Greenwood. Mm-hmm. There's going to be just because they may have 5 judges holding court, and there's all kinds of hearings going on, whereas Greenwood would only have 1. But it just based on the personality of the judges and their preferences and how they like evidence presented, it does change things. I have judges that, for just as a simple example, the judges when drug use by a parent is an issue. I have judges that if we hand up a drug screen, they just say, okay, thank you, and accept it into evidence. I have other judges that, will require, particularly if a defendant objects, and say, okay, well, do you have the person from the lab present to testify that this is, in fact, this parent's drug screen and that it's accurate and that nobody's tampered with it? Well, that's a big difference between handing up a piece of paper versus 30 minutes of testimony about whether that drug screen is admissible. So, and that does vary a bit based on the judge. But over time, we kind of know which judges are more lenient on some of those issues.
So different counties may have to prepare their cases just a little bit differently, depending on how court in that county works. And that should be something that a foster parent can ask that caseworker about what to expect as well, right? Right.
And hopefully in those situations, if we know that that's going to be a sticky issue for something like that, or we're going to, as I said earlier, if we know we're going to need a lot of expert testimony, that's when we're going to ask for what we call a day certain and separate from the normal docket, because we're not going to be able to get to all that in an afternoon with 20 cases. It's not going to happen. So, and it's going to take longer. So at that point, we're going to ask for more court time. The difficulty is, depending on how busy the county is, that could be a month from now, it could be 3 months from now, 6 months from now. I just tried, I didn't try, but part of my team, they requested a 2-week trial in family court. And it took us 9 months to get that scheduled because the court had things scheduled that far out. So that's extremely rare, thankfully. But I did a 3-month trial in December, and it had taken 6 months to get that scheduled. So the more time courts have limited amounts of time and resources, so the more time something's going to take, the longer it takes to get it scheduled. And we do our best to try to work around that, or ask the court to give us priority, or see if there's some way we can reach an agreement. But again, depending on what the allegations are, there are some things we're not allowed to negotiate and settle, like a sexual abuse case. We're not allowed to reduce that to something less. We have to put that parent on the central registry, and they tend to fight those pretty aggressively.
Right. Well, thank you so much. I mean, you really have just given us a wealth of information. I really appreciate it. Just really quickly, you had talked about a couple resources previously from the Children's Law Center. Can you just tell us, maybe we've linked to those. Can you maybe tell us a few things about where we can find those, or other resources that?
Sure. On the link, this document is called the Legal Guide for Foster Parents. It was created by the Children's Law Center. And it gives a pretty good overview of the court process and foster parents' role in that process, and just some some just good general information. It just got updated this past year, so it's a really excellent resource. And there's lots of other, if you get the same place where that document is, there's lots of other interesting publications that the Children's Law Center has produced, which may or may not interest you. It's for as a foster parent, but it's if you're into this and want to find out more about it, it talks about things like interviewing children, law enforcement interactions and child welfare. So that's one of the best. That's a great site for resources that are open to anybody. And I tell people, I'm always happy. I have folks email and ask me questions, and I try to get answers if I can. I can be emailed at robert.cone@dss.sc.gov.
And we'll put that in the comments here too.
So, feel free. I'll try to check on cases and see what's happening. I can't guarantee that I'm going to wave my wand and you're going to have a hearing next week, but I'll certainly find out and make sure that we're doing everything we can to get that case moved along.
Awesome. Well, thank you so much. And thank you all for joining us. Have a great day. Bye.